Hello students, today I am going to discuss about right to equality as given under Indian Constitution. So first of all I will discuss about that article 14 to 18 of Indian Constitution discusses about the right to equality. But in first part I will discuss about right to equality as given under article 14 of the Constitution, which is equality before the law. Article 14 states that state shall not deny to any person equality before the law and equal protection of the laws within the territory of India. So this article uses two phrases: equality before the law and equal protection of the laws. Here you must note that the term equality before the law is taken from common law of England, and equal protection of the laws has been taken from American Constitution. And you must note that under American Constitution it was not given under original Constitution, but it was inserted by 5th and 14th Constitutional Amendment Act. So let us see what is meaning of these two phrases. Equality before the law, it implies the absence of any special privilege to any person. It implies there should be no discrimination before the law on the ground of rank, office, etc. So you can say the law should be equal and should be equally administered, or in other way you can say like should be treated alike. As so article 14 states that every individual is subject to the jurisdiction of ordinary court irrespective of their ranks. Now let us see what is meaning of equal protection of the law. It appears a corollary of equality before the law. It is based on last clause of first section of 14th Amendment of US Constitution. As I told, it was inserted by 14th Constitutional Amendment under American Constitution. So equal protection of the laws directs that equal protection should be secured to all persons within the territorial jurisdiction. It implies that protection should be without any favor and without any discrimination. And it means that equal treatment in similar circumstances, not in different circumstances. So both in the privileges and liabilities imposed by law, it should be equal treatment within equal circumstances. So it provides obligation to state which it should achieve by bringing about necessary social, economic changes to ensure every person enjoys such equal protection. So if we see equality before the law as inserted under it, as given under Indian Constitution, it is not unrestricted. There are certain exceptions also. For example, you can say delegated legislation, administrative adjudication. So the main spirit is that if state is giving benefit to certain section, certain class, then that benefit must be under valid classification, whom state are giving benefit and whom they are putting in other category. So the test classification is that the classification must be just and reasonable and should be in relation to need and purpose of law in respect to which classification is made, and the object of the classification should be lawful. In the case of Subramaniam Swamy versus CBI, it was held that if object itself is discriminatory, then explanation that classification is reasonable, having rational relation to the object sought to be achieved, is immaterial. So it is based upon two principles: intelligible differentia, means intelligible reason for classification, and rational nexus, means relationship between classification and desired result. Here are also certain cases I must mention. In Chiranjit Lal Chaudhary versus Union of India, it was held that single person law is also a class. In other case, Menka Gandhi versus Union of India, it was held that when a classification left to the discretion of executive in the institute, so, certain guidelines has been given. If no guidelines are given, such act will be held violative of Article 14, and such legislation would be struck down by the court. You must also note that Narges Mirza case, where Narges Mirza versus Air India, so in first part, this was the thing which I want to discuss about the Article 14 of Constitution. So thank you very much.